All right, today we're opening up a case file. This is a fascinating story, a real-life administrative battle between a single homeowner and his HOA, and it all revolves around one thing: transparency, and what happens when a single blacked-out line on a document spirals into a full-blown legal fight.
So let me ask you something. Imagine you request a financial report from your HOA, and when you get it, there's just one single, mysterious black line redacting some information. What do? Do you just shrug and let it go? Or do you start digging? Well, one homeowner decided to dig.
Okay, so let's get into the story. It starts not with some big dramatic event, but with this simple piece of paper. A totally routine request for some documents that ended up leading to a pretty surprising discovery.
So, picture this. It's March 31st, 2025. A homeowner, a guy named John Khran, sends a formal request to his HOA, which is called Tonto Forest Estates. All he wants is a copy of the monthly check register, a super standard financial document that just lists the checks the association wrote. Should be pretty straightforward stuff, right?
Well, a few days later, the documents show up in his mailbox, and as Mr. Krahn is looking them over, he spots something odd. On the check register for March, there's one single line: a payment to a law firm, Maxwell & Morgan, and part of it is just blacked out. You can see the date, the check number, the payee, but the details? Totally gone. Redacted. I mean, what are you supposed to think? The immediate question, the one that would pop into anyone's head, is what was under that black line? What information did the HOA not want him to see? And that one question, well, it set off a chain of events that would eventually land everyone in front of an administrative law judge. So Mr. Krahn felt like his legal right to see the association's records was being violated. And he didn't just send off an angry email or make a phone call. No, he escalated things. Big time. He filed a formal petition with the state. Now, this whole dispute really boils down to this one specific Arizona law. The law says that HOA financial records have to be made reasonably available for any member to examine within 10 business days of their request. The key phrases here are reasonably available and that very strict 10-day deadline. That's the battleground.
And this timeline just lays it all out perfectly. The request goes in on March 31st. The HOA mails out that redacted document on April 10th. Now, the legal deadline for them to comply was April 14th. By May 19th, with the issue still not resolved to his satisfaction, Mr. Krahn officially files his case. And just like that, we have a formal legal proceeding on our hands.
So, let's fast forward to the hearing itself, which happened on October 22nd, 2025. This is where both sides finally get to make their case to an administrative law judge and, hopefully, get to the bottom of that mysterious blacked-out line.
From Mr. Krahn's perspective, this was about a much bigger principle. He basically argued, look, this isn't just a petty squabble over one line item. This is about making sure our HOA is transparent and actually follows the law that guarantees us, the homeowners, the right to see the records.
But the HOA president, Dwight Jolivet, he came to the hearing with a completely different story. His argument was, hey, we did comply with the law. He claimed that even though the copy they mailed out was redacted, they had put a clean, unredacted version up on the community's online portal before the deadline.
And this brings us right to the core of the whole disagreement. Was this an intentional move by the HOA to hide something, or was it something else entirely? Well, the HOA's entire defense was built around one key explanation. It was all just a simple mistake.
So after all the drama, what was the huge secret hiding under that black line? Was it some scandalous detail? Nope. It was the text 5703 Legal General. That's it. It wasn't privileged legal advice. It wasn't some sensitive secret. It was just a boring accounting code and a budget category. The HOA president explained that the redacted version that got mailed to Mr. Krahn was actually a draft meant for their attorney to review. He testified that a clerk just grabbed the wrong version and put it in the mail by accident. He called it a simple miscommunication, a clerical error, one the board didn't even know about until the lawsuit was filed. Okay, so this is where the whole case really hinged on one tiny detail: a timestamp. The HOA showed the unredacted document from the online portal, and at the bottom it was stamped, "Report generated 4/14/2025, the exact day of the deadline." Their argument was, see, proof it was available in time. But Mr. Krahn fired back saying, hold on, that only proves when the software created the file, not when you actually uploaded it for me to see. The entire case hung on what that one digital footprint really meant.
So after hearing both sides, the homeowner arguing for his rights, the HOA defending it as a simple mistake that they fixed online, it was all up to the administrative law judge to make the final call.
The judge's official findings basically laid out the facts like this. 1. Yes, the HOA absolutely did mail a redacted document by mistake. 2. That mistake was probably just an unintentional clerical error. And 3. This is the important part, an unredacted version was made available online and Mr. Krahn himself knew it was there by April 21st, which was well before the case went to a hearing.
And here's a fascinating little detail. Mr. Krahn wasn't trying to get a big payday out of this. He only asked for a symbolic civil penalty of $1. His goal wasn't to punish the HOA financially. It was to get a formal ruling that a violation happened, hopefully to make sure it wouldn't happen again.
And this right here, this quote from the judge's final decision, is the legal reasoning that decided the whole thing. The judge said that because the correct, unredacted document was eventually made available, the original error had become legally moot. In other words, in the eyes of the law, the problem had been fixed before the case was decided, so there was nothing left for the court to rule on.
And with that reasoning, the final verdict came down. The homeowner's petition was dismissed. Even though the HOA made the initial mistake, the judge ruled that because it was corrected, there was no longer an active violation for the court to address.
So this leaves us with a really interesting question, doesn't it? If a mistake is made, but it gets corrected before a final judgment comes down, does the original mistake still count as a legal violation? In this specific case, the law's answer was no. It's a pretty powerful reminder that sometimes, in these legal battles, the winner isn't decided by who made a mistake, but by who took action to fix it.